Hello and welcome to our live video on YouTube. This is Judge Granville. He is a Superior Court judge in Maricopa County. And yesterday, on the 12th day of June 2018, he heard from Chinese men and women who wanted to keep him from reducing a charge against the murderer from first degree to second degree murder. The case involves a 19-year-old college student at ASU who was brutally murdered in the street at 2:30 in the afternoon in January of 2016. She was simply driving down Broadway toward McClintock in Tempe, Arizona, when Holly Davis, a convicted felon with a gun, purposely bumped into her from behind and then got out of the car, waving the gun, firing 3 times through the driver's side window, killing the daughter, the cousin, the family member, the 19-year-old. And this is the hearing yesterday in which the family begged the judge not to reduce the sentence from first degree to second degree, which would allow Ms. Davis to get out in 25 years as opposed to doing life in prison. And you'll see the result of that. You'll also see in this video the father looked like he's about to jump on Ms. Davis, but instead stares her down and then yells at her right in court, face to face, calling her in Chinese a piece of trash, among other things. Let's look into the video now. The first part of the video, just a few seconds, doesn't have much sound, but the sound picks up as we get going with this video. You're going to hear, first of all, from an attorney who's representing the family, and then you're going to hear from the cousin of the murdered teen, the cousin coming from Great Britain. She's Chinese, studying in Great Britain. She speaks quite eloquently. And then you're going to see and hear from the father, who is obviously distraught and nearly takes off after this woman. There's a few Chinese folk in the right hand of your screen who are there attending. The cousin is toward the back there in the front row. That's her right there. Her name.
We have a list of persons that wish to address the court. I will allow them to address the court in any order that they wish. We do have an interpreter available.
We have an interpreter and there was counsel, so I'll be happy to hear from any of those folks in whatever order they wish.
There is the defendant in orange.
Judge, before we proceed, may I request of the court, I do not know who this gentleman is. I know he's the representative of the victims. I'm happy to let him speak. I don't believe he's filed a notice of appearance. I would just request that he file a notice of appearance in this case if he's going to speak on behalf of the victims at some point in the next day or so.
I'm Dan Duncan, and I'm representing the family here with regards to...
Let him at least get his first introduction out, and then I'll address your concern.
Thank you.
I'm here representing the family pursuant to the Arizona Constitution, Article 2, 2.1 Victims' Rights Law, as 12B or other lawful representative, and we're addressing the court on behalf of the family.
Mr. Tavatoli, I don't read requirements of speaking on behalf of the victor. Objection is timely but overruled.
Okay, thank you.
Mr. Duncan, you may proceed.
Thank you, Your Honor. Your Honor, counsel, parties present, distinguished members of the Chinese consulate, Mr. Tang and Mr. Fao today, and relevant reviewers, and also Mr. Yang of Phoenix International, representing the Chinese community. I'm speaking on their behalf. I'm Dan Duncan. I'm also a victim in this case, as far as I'm concerned. I'm speaking of and on behalf of the as an assigned representative of the James family. And we are speaking in opposition to the Maricopa County Attorney's Office pending unjust and improper plea agreement. And the first thing I would like to address is Prosecutor Lowe's misconduct under the AZ Constitution, Article 2, 2.1 Victims' Bill of Rights. The James family has a right to be informed of all proceedings where the defendant has a right to be present. It has been violated. And as the James family has a right to confer with the prosecution before any disposition of the case and be informed of the disposition regarding sentence negotiations and pleas, that has also been violated. As the nature of the crime, Prosecutor Lowe dismisses that all the requirements of first-degree murder have been met. Holly Davis committed 14 serious felonies in her actions on the day of the homicide. Holly Davis created grave risk of death to 6 innocent people, including 3 children and 1 unborn child. Holly Davis's actions on January 16, 2016, at approximately 2:50 p.m. were especially horrendous, cruel, and done in a depraved manner. Holly Davis's actions were cold, calculated, without pretense of moral or legal justification, and as such, that all satisfies a first-degree murder charge and conviction, in my opinion. As to potential mitigating evidence, it also supports first-degree murder charge.
You're watching a court hearing that occurred yesterday on the 12th day of June 2018. This hearing is to ask the judge, the family of the victim, a 19-year-old ASU student, to reject a plea agreement between the prosecutor and the defense here, in which the defense agrees to plead guilty and gets a second-degree murder charge instead of a first-degree murder charge. That has really upset the family. They've come from China and from Great Britain to talk to the court. There is the defendant right there in orange, sitting. Later you will hear and see the father of the victim face off with her and nearly jump on top of her. And that'll come up in a little bit. Next, after this attorney talks, we'll hear from the cousin of the victim. She is very elegant as well.
At age 32 at the time of the offense, Davis was fully aware of her actions and the potential consequences. Davis' capacity retreated to the vehicle and advised Ms. Jiang to drive away. She was unable to do that before Ms. Davis approached the vehicle with her handgun and shot you 3 times through the driver's window. And in doing so, in trying to escape, this had a traffic collision that injured additional parties that I've described. There was no arrest or mitigation with regards to Davis's actions. Davis's degree of participation included premeditation, arming herself, deliberately ramming used off vehicle, threatening used passenger, deliberately shooting you, and then avoiding arrest with flight to escape capture, followed by making false statements denying any involvement when confronted by the police in an effort to avoid arrest. With the attempted and or actual destruction of evidence before the police arrived. In the homicide, Davis committed 13 additional felony crimes, which the prosecutor seems to have excused. As to defense Davis's character, she was a felon in possession of a gun. She's a known drug addict or abuser. She actually is a derelict with no employment or source of income or housing. And she was apparently deemed to be an unfit mother, and she's having difficulty visiting her child. Her background is covered adequately in the pre-sentence investigation, which places her 2 points short of a high risk. As to the improper and unjust plea agreement, in Prosecutor Lowe's previous case, the state of Arizona versus Roe, Lowe commented on the murderer, Jerro's admission of guilt and conviction for first-degree murder.
He's arguing law.
And no possibility.
I'm okay with him making this statement, Judge, but he's arguing the law. I don't think that's appropriate, and so I'm objecting to his colloquy here.
And if there's an objection, I ask you to pause. And the only issue for today is whether I should accept this plea agreement or reject this plea agreement.
May I be allowed to at least quote her words in a previous case?
For what relevant purpose?
Well, because it shows it shows bias, potential bias, and it shows unequal treatment for Ms. Xu. You.
Go ahead, Mr. Duncan.
Okay. The prosecutor though said, in that case, a drop in the bucket that the plea to first degree and life imprisonment was a drop in the bucket compared to the damage he did to the community. Now, in this case, prosecutor Lowe apparently ignores a multitude of Arizonians, the Tempe police, the Tempe and Phoenix communities, which were all directly affected, and also the Asian communities who, by their hard work and investment, have brought an economic revitalization characterized as bringing Phoenix
Mr. Duncan,
to slums to growth.
that is not a relevant issue in my determination.
It's not irrelevant for us.
Despite Lowe's concern in one case for the community, she apparently has none in this case. Prosecutor Lowe has expressed to the family that she believes that if this case was to go to trial, there would be possible discrimination against the Chinese involved. And we reject that as, and I would submit to the court that the petition in support of Ms. Jiang has now reached over 12,000 signatures. And these signatures are from across the state of Arizona. They're also, again, from the law enforcement communities in various jurisdictions and states, and from criminal attorneys, from a multitude of professionals at various large corporations such as Microsoft, Boeing Aircraft, Spectrum Communications, East West Bank, JPL NASA, and many other concerned citizens. From all across the world, these petitions have come in from Australia, from Europe, from everywhere. And I would submit this petition for the court's consideration, if I may.
You may not.
The Jiang family also hears the argument that the need for frugal allocation of resource money is best served by the plea agreement. In Mayor versus City of Chicago, the Supreme Court of the United States of America, Justice Berger commented on the economy argument, stating, unfortunately, one consequence.
I'm aware of the case law regarding the money issue. You may go to your next point.
May I at least indicate that the justice said economy is not an objective of the system.
Mr. Duncan, go to your next point. You have one.
In our opinion, we and the communities that we're speaking for are very discouraged and concerned about how this court can possibly justify the kid gloves matter in which the prosecution, including the county attorney Bill Montgomery and prosecutor Lowe, are now treating the Yu family. It's been shown that the county attorney would like to justify this as a road rage incident. This is anything but a road rage incident. Road rage has nothing to do with this case whatsoever. In closing, with 19-year-old promising ASU student Yue Jiang being murdered randomly in cold blood in broad daylight by an ex-felon drug addict with a gun bent on killing everyone to gain attention, Yue, at the hands of Holly Davis, was given a death sentence. The Maricopa Prosecutor's Office should weigh and give that great weight. There is no confusion regarding culture or language here. The entire world community is looking to and seeking justice in this case. The total senseless killing causing additional unnecessary anguish by the thought of this totally improper plea agreement is of great concern to the communities involved. On January 16, 2016, Holly Davis relinquished her right to ever again harm another person. The students and public at large should never again be exposed to the likes of Holly Davis. There is not a parent on this planet that would elect Holly Davis to be back on the street near their child today, tomorrow, or in the future. We respectfully submit and implore your honor to summarily reject any pleas or disposition less than one of first-degree murder with life sentencing. With justice for Ms. Yue Jiang as called for by the thousands of voices standing in her place here today. I would also like to submit to your honor Arizona State University in support of the strongest penalty possible for this crime, signed by Michael M. Crow, President. If I may approach. Thank you, Your Honor.
Next will be the cousin, Katherine Xu, from Great Britain. She came to support her cousin who was killed by that woman there in orange on the left of your screen.
Honorable Judge, my name is Katherine Xu. My name is Yue Jiang. I'm cousin of the victim Jiang Yue. And thank you very much to give us the chance to speak in front of you. And the only reason why we'll be here today is just to fight for the justice for our cousin. And unfortunately, this is the first time we can raise our voice in front of you. And please, we're here offering honor to reject the plea bargain because from the below 2 points of view. First of all, we find ourselves betrayed in this case. And secondly, we found ourselves misguided in this case. Since 2016, when the crime happened, and Jiang Yue's father and her auntie came to the U.S., had the conference with the prosecutor and the police station, and they told us under the 14 felonies, Holly Davis would definitely be charged under first-degree murder and life imprisonment, with no doubt. That is what we have been informed. And unfortunately, after 2.5 years, we get the second-degree plea agreement on the news, but not from them. We didn't even get any knowledge about the plea bargain before it shows on the news. As what we understand about your state law, the defendant has the right to be silent, has the right to get a lawyer, has the right to speak in court. But how about us? How about our victims? We don't have anything, we don't have any rights. And the only right we have is just involved in this case and to attend any negotiation related to the plea bargain or whatever. But they took our rights away. And the first email after they went back to China was the hearing notification. And we called them the first time when we got that. We said, do we need to reply in any sense, or what should we do? And what we've been informed was well, it's just like a legal progress and your procedure. You don't actually need to attend, because the only thing you can do is just to sit on here. And if you are not attending, you don't need to reply. And I think that obviously shows on the notification itself, we don't need to reply if we don't attend. And that is why we didn't reply any hearing notification emails. After this time, I came to the U.S. by 19th May myself and Jiang Yue's auntie, and we met Stephanie Lowe, our prosecutor, and the victim's office, Deborah, on 22nd May, 1:30 p.m. And we asked, why didn't you email us or try to inform us anything about that before you hand the plea bargain to judge? And funny thing is, they said, we're sorry, we didn't know that you didn't receive our email. But there's even funny thing is, we had received the emails before the date they informed, and they said they tried to email us, and after that, just the most important thing was missing. And wait, well, there is a way. Probably our email box had got some problems. We didn't get that. There is still a risk. And I tried to reach the other victim in this case, Yue Jiang, the boyfriend of Jiang Yue. And I said, did you receive anything, any information about plea bargain? And he said, absolutely not. And he did a screenshot to show that he didn't receive anything about the plea bargain or attend any draft to discuss about the plea bargain before. And I asked our prosecutor and the victim office to show us if you really send us the email, please prove. And funny thing is, for me personally, what I would do is I would forward the sent email to prove I did, or I'd probably do a screenshot to show that I did. But so far, I got is like a copy and paste of the draft of that email, the mentioned email. But we don't think that is strong enough to show we did. And in that point, we trust to let us know about the plea bargain is the main progress and actually the biggest rise for us. At least as prosecutor and the victim's office, you should try your best, try all the ways you can reach us and get the response from us, or probably through our Consular General. That was how you tried to reach us the first time when the crime happened, but they didn't. We feel betrayed when we got the information from the news, and me tried to email them to Mr. Joseph. I hope he passed my email to you, my honorable judge. The only thing we're coming to require to claim is nothing to do with the civil compensation. It's nothing to do with the donations. We're not coming for money. The only thing we want is the justice. And after we can, this time, 19th May, we meet with the prosecutor. And now, when we are thinking back, I find myself being misguided at that time when we were talking to her, because she was trying to tell me that why she's going to have a plea bargain is because there is a risk if you really put this case on trial, you may probably back to second-degree murder, and then it's really rely on the judge to decide between 10 to 25. And well, we didn't exercise on your cases, or your previous cases. Didn't know who you were actually. So that was really scaring us. We don't know how much we can get back just for the justice. And she was trying to say that, she said, the things we don't want to do is to let the murderer, the monster, to go to jail before like less than 25 years. So that is why she wants to tie your hands to 25 years. I said, why don't you try first-degree murder with 25 years instead? You did the second-degree 25 years. And she didn't answer my question directly, and she was trying to tell me, listen, let me just ask you, what's your family client? Are you just asking for the first-degree murder instead of second-degree, or do you want her like life imprisonment or whatever? I said, no less than first-degree murder, because if we choose the first-degree murder to second-degree murder, that totally changes the definition of this crime. We cannot accept that with no doubt, and you cannot do that. And after that, after the conversation, we did some exercise about your case, and then we find out you, our honorable judge, you do the right thing. We really want to put this case on trial. We trust that people in Arizona don't want these things happen again. We don't just fight for our daughter, we also fight for the whole society. We fight for all international students. We fight for, people don't have vote right. We fight for everyone. We fight for the security. We fight for the community. So, and in that conversation we had with Ms. Lowe and Ms. Deborah, we were told that your jury made kind of funny in this case. They wouldn't have any knowledge about if they have any racist with the Chinese region, with the international students, or blah, 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 blah. Yeah, there's probably a risk. I don't know, but we think every parents just like us, every family like us, wouldn't want this happen again. And we trust that even after 25 years, when this murderer get off the jail, she's only about 57. She had the power or ability to commit another crime. Probably she's coming out just to kill someone else, because that was what she did. She went to jail for three years, and when she came out, she didn't feel guilty about what she did, and she killed my cousin. Just so innocent. My cousin was so innocent. Yes, my cousin wasn't picked up, but that was really unfair. We just don't want that to happen again. Not for any family. We don't want this what we have now. We don't want to any family like us to get through things just back again. And that's what we want to say is, please, our honorable judge, no less than first-degree murder and life imprisonment. What we want to do is to protect the whole society and fight for the justice for my cousin. Thank you very much.
Thank you.
Thank you.
Sir? 法官大人，这个人罪协议，我们坚决不能承受。我就不信了。美国的陪审团也好，法庭大人也好，所有的美国人民也好，有正义感的，就允许这样不公平的事情在他们的这里发生。
I don't believe, in the people of the United States and the jury and the judicial system is accept that unfair disagreement.
我也请法官大人听听我们所有的全球的华人，对所有有正义感的人的发出的声音。
Today, Your Honor, I beg you that listen to the whole world Chinese people which try to express themselves.
请求法官大人撤销这罪协议。
Don't accept the pre-settlement.
给这个残酷的凶手
以最严厉的惩罚。谢谢。
I would like to crucial the murder that have the maximum penalty. Thank you.
Thank you, sir.
谢谢。
Sir, you can come back on, if the plea is accepted, you'll be able to address me regarding sentencing on Friday. Time for that. Sir, you need to go back to your seat.
Apparently that's it, Your Honor. Thank you.
With respect to today's proceeding, the court finds that Jim's loved ones only have standing with relating to the counts. Folks across the state and country have no standing as victims, and their concerns are not my concerns. The court has always found that the county attorney has used every reasonable effort in every case to afford victim rights. I have no reason to believe that that was not done here. Folks who love Ms. Jiang believe that justice can only come from a finding of first-degree murder. None of us can say that those feelings are not valid. If I were to reject the plea agreement, Ms. Jiang's loved ones can never be assured of that first-degree murder finding. Because if the court rejects the plea, this case would go to trial. As a judge, I have presided over many death cases. Let me respectfully respond to Ms. Jiang's loved ones about what that experience would be. None of us can guarantee that a finding of first-degree murder would be made. That finding would have to be made by 12 lay folks who will do their best to do what they think the law and the facts lead them. The issue that they will be asked to decide is whether this is a first-degree murder, whether any of us believe murder is by what 12 lay folks come to believe upon their good faith interpretation of the evidence presented in the courtroom. What differentiates first-degree murder from second-degree murder is the concept of premeditation. Or she knew would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. An act is not done with premeditation if it is the instant effect of some quarrel or heat of passion. How 12 folks apply this definition to the evidence presented in this courtroom is completely up to them. Whether there is premeditation in this case would have to be found by the unanimous agreement of lay folks trying their best to do the right thing. Any trial will involve the allegations the state has of what Ms. Davis did will not be focused on Ms. Jiang's life and her character. If the case goes to trial, there will be an appeal where the claims of error will be that the prosecutor and police made error, that the judge made error, that the defendant's attorneys made error. If Ms. Jiang's name is mentioned at all in any of these pleadings or rulings, it will only be in passing. Accepting this plea agreement means that we will have a sentencing on Friday, where Ms. Jiang's loved ones may share on what a treasure she was and what a tremendous loss. And if the plea agreement is rejected, any trial will have to be focused on the ugly facts of how she died. Any trial will involve many weeks focused on the life and circumstances of Ms. Davis and not much on Ms. Jiang. If the plea agreement is accepted, the prospects of appeal are limited in time and in scope. If there is a trial, appeals are more complex and time-consuming. If the plea is accepted, Ms. Jiang's loved ones can remember her as she lived and not be forced to think about what Ms. Davis did to her or on Ms. Davis's rights through the years of appeals. Having considered the factual basis presented on February 23rd, having considered prepared for Friday's sentencing, and having considered the family's comments today, I will not withdraw the acceptance of the plea agreement that was entered in on February 23rd, and I affirm the sentencing for Friday. Ms. Lowe, anything else for today?
Yes, Judge, I'll reserve most of my comments for the sentencing on Friday. I would like to point out, though, Judge, that there's a lot of disparaging statements made about my client, and understandably so on some level, but there is a sentencing memorandum that I have submitted to the court. I would encourage the opportunity for the victims in this case to read that and see the person who Holly Davis really is, rather than the monster that they think she is. Thank you.
I have always interpreted the request to seal sentencing memorandum as to being not sealed to victims who have a right to review it. So I would leave them, if they choose to review it, even though I have granted the request that they be filed unsealed. We'll reassemble on Friday. Adjourn.
So there you have it. Holly Davis, right there in the middle of your screen, will be sentenced Friday, the 15th day of June 2018 at 10 a.m. in the morning. Our cameras will be there. What a hearing as the father faces off with the murderer of his 19-year-old daughter. He came all the way from China to do that, and he was able to do that. He'll get one more chance to talk to her and about her on Friday. I'm Tom Simon. Thank you for joining us. Bye-bye.